So a new case challenging the NFA and its restrictions on short-barreled rifles is now in front of the Supreme Court. But because Congress recently passed the $0 tax on suppressors and SBRs in the Big Beautiful Bill, this case is now even more interesting. So let's break down what is happening. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. You guys know that they have great supplements, protein powder, pre-workout. I used a lot of their products even before they became a sponsor of the channel. But one of the amazing things about 1st Phorm is they're pro-freedom, pro-America, and they support the Second Amendment and what we talk about here on the channel. Not a lot of companies would do that, but they support the Second Amendment, so they want to support what we talk about here on the channel. So if you guys want to support a company that believes in what we do and they believe in the Second Amendment, check them out, please, using the links down below in the detail section and also in the pinned comment. And one of the things that they're doing special for my viewers, if you use that link, if you order something $50 or more, you will get a free 4-pack of energy drinks. Now, as I mentioned in the intro, in this video, we're going to be talking about a new case and a very important NFA challenge that is now in front of the Supreme Court. This case is called U.S. versus Robinson, and it's a challenge to the NFA and its SBR restrictions. This challenge asks for the Supreme Court to find that the NFA's restrictions are in fact unconstitutional under the Second Amendment as they apply to short-barreled rifles. This is a case that was ruled on by the 11th Circuit Court of Appeals, and in that decision, the court there found that the NFA does not violate the Second Amendment. They also ruled that the NFA is not an unconstitutional tax on a fundamental right. That ruling by the 11th Circuit has now prompted Mr. Robinson to seek Supreme Court review. Now, this is one of the Second Amendment cases that is now seeking Supreme Court review. This is the second one that we've seen that involves SBRs and the NFA's restrictions. So this is the second major case about the NFA and SBRs that is currently in front of the Supreme Court. This is now even more interesting because Congress recently passed and Trump signed into law the Big Beautiful Bill, which included a reduction of the NFA's tax on SBRs and suppressors to $0. Now, the facts surrounding this case are actually kind of interesting. Back on September 9th, 2022, law enforcement officers responded to a complaint of a suspicious vehicle that was parked in front of a house in Florida. When the officers arrived, they observed that Mr. Robinson was asleep in the car. He was in the driver's seat, but they also noticed that there was a buttstock of a rifle that was next to him. Officers used a flashlight to view inside the car, and they woke up Mr. Robinson. Officers ordered Mr. Robinson to place his hands on the car, steering wheel, but rather than kind of complying with the officers there, Mr. Robinson, of course, like a dummy, decided to drive away. Officers, of course, followed him. They turned on their lights. Mr. Robinson eventually did stop his car, and then he was detained. After he was arrested, they searched his vehicle, and they recovered a loaded short-barreled rifle and a separate upper of a rifle that was also included in the vehicle. It was a separate upper that was a 16-inch barrel, but the firearm that was configured in its own right was an SBR. The officers gave him his Miranda warnings, and Mr. Robinson then explained that he had bought the rifle, I believe, in Tampa, Florida, and that he did not know that he needed to register it as an SBR. They, of course, performed a search of the National Firearms Registration and Transfer Record, and they found that, of course, this was not a registered SBR to Mr. Robinson. He was then charged with violating the NFA and being in possession of a short-barreled rifle in violation of the NFA, and during a bench trial, the district court found that Mr. Robinson was, in fact, guilty, and it later imposed an 18 months probation on him, and he only got 6 months served at home in confinement, essentially home arrest. Now, as a result of that conviction, Mr. Robinson then appealed the conviction up to the 11th Circuit Court of Appeals. And on appeal, he argued that the statute and conviction, which was related to the NFA, does violate the Second Amendment in light of the New York State Rifle and Pistol Association versus Bruin ruling. He also argued that the NFA is an unconstitutional tax on the exercise of constitutional rights that exceeds Congress's powers under the 10th Amendment. However, on review, the 11th Circuit Court of Appeals rejected all of Mr. Robinson's Second Amendment claims and then also that tax argument. In the decision, the 11th Circuit stated that, "Here we conclude that Miller remains binding as the Supreme Court has not overturned it. As a lower federal court, we must leave it to the Supreme Court to overturn its own precedents and to limit its own precedents' applicability. As shown by the history laid out above, the court has yet to overturn or limit Miller. Accordingly, the NFA's registration requirement for short-barreled rifles and shotguns is constitutional. Miller and our precedent upholding the NFA against Second Amendment challenges and relying on Miller, such as Tagg, Bulletet, and Wilson, remain binding. Given that the NFA's regulation of short-barreled shotguns is constitutional under Miller, we turn to whether the NFA's similar regulation of short-barreled rifles is similarly permissible under the Second Amendment. The district court explained that in its view, there was no meaningful distinction between short-barreled rifles and short-barreled shotguns. Other courts have reached that same conclusion. The 11th Circuit went on to state that a successful Second Amendment challenge to the NFA must distinguish itself from the challenge the Supreme Court rejected in Miller. Here, Robinson has not established how the distinctions between short-barreled rifles and short-barreled shotguns presents a relevant and material difference that would make one regulation constitutional and the other not. We also disagree with Robinson's contention that the NFA is akin to a licensing scheme found unconstitutional in Bruin. The NFA does not require applicants to show any atypical need for armed self-defense so that they do not implicate the same concerns present in Bruin. They then concluded the decision by rejecting the argument that the NFA is an unconstitutional tax on a fundamental right. So in this case, the 11th Circuit Court of Appeals not only rejected the Second Amendment challenges to the NFA and the restrictions on SBRs, but also they claimed that the NFA is not unconstitutional, it's not an unconstitutional tax on a right, and that it should not be treated in the same way as the First Amendment, but instead the Bruin analysis also applies to this tax question. On the Second Amendment question, they rely heavily on the Supreme Court's Miller decision. They state that Miller already found that short-barreled shotguns are dangerous and unusual firearms, and therefore they can be restricted. They believe that there is no meaningful distinction between short-barreled shotguns and short-barreled rifles, and therefore Miller stands as a valid precedent, and also it remains valid against SBRs. They state that until the Supreme Court changes their decision or clarifies this SBR issue, they are bound by Miller and they're going to follow that Miller allows this type of restriction. Now, in rejecting the tax argument, they claim that Bruin's decision actually forecloses this type of tax argument since Bruin contemplated that maybe some objective restrictions like fees and tests would be permissible under the Second Amendment. So they claim that Bruin in that analysis also covers this tax question and kind of makes the whole tax question invalid, which in my opinion is not correct. But regardless, now this decision and that ruling by the 11th Circuit is up for review in the Supreme Court. Mr. Robinson is now seeking a writ of cert to the Supreme Court and asking them to review what the 11th Circuit said. He recently received an extension to file his petition by Justice Thomas, so his official petition to the Supreme Court will actually be due on July 18th, so just in a few days. It's now going to be interesting to see how he addresses the recent NFA tax changes, maybe how this will change now because of what happened in the Big Beautiful Bill. Regardless, this is now one of the major cases that's in front of the Supreme Court dealing with the NFA and SBRs. This is the second case that we've talked about. The other one is the NRA case that they filed, which is Rush versus the United States. So now you have two NFA SBR challenges that are in front of the Supreme Court seeking review of this issue. And this is all coming on the heels of Congress changing the NFA tax requirement. I will note that the Supreme Court has been hesitant to step in on these big two-way cases lately. They rejected the rifle and magazine ban challenges last term, so maybe the NFA and SBR challenges will probably be a little too controversial for them. But the hope is that now, maybe since the tax has been reduced from $200 to $0, this might create a unique enough dilemma for the Supreme Court, a unique enough situation where the Supreme Court actually wants to step in on this NFA issue when it deals with SBRs. So that's what's currently going on in this new NFA/SBR challenge that's seeking Supreme Court review. So as this develops, I will let you guys know. If you like this video and you want to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, you can check out my website, armedscholar.com. We have a lot of free resources over there for you. You can get the free legal guide. All you have to do is put in your email over there and you get the free PDF legal guide. And then we also have some channel merch over there, some shirts that you can get. And then also we have some daily deals you can check out to save a little bit of money. So again, thank you guys so much for all of your support. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.